Dhaka International University.
Digital evidence is more and more important all around the world. One reason that my government is interested in helping build capacity in Bangladesh is we would like to be able to exchange information. Professor Supan talked about mutual legal assistance treaties. There isn't one between the U.S. and Bangladesh, but there are ordinances that we can proceed under. Of course, most of the evidence that the U.S. produces is digital in nature. Most of the evidence that Bangladesh produces is oral or testimonial. Our courts prefer digital, and Bangladeshi courts prefer oral or documentary. So, in order to make it easier for our governments to work together, my government is encouraging me to work with Bangladesh to consider more use of digital evidence. Just for a point of reference, in the United States, I can't think of a case that I have been involved with that has not involved at least some aspect of digital evidence. And I think here, as technology changes, there's more and more need for ways to use digital evidence in trials here. Looking at each of you, I'm sure you have a cell phone. Imagine not being able to use any of the data on that cell phone at trial. Most of us anymore I do my banking using a cell phone. I do more and more things electronically and not with paper. So if I can't use what's in my digital devices, then a trial is really not going to go anywhere at all. Professor Supan talked about how a document is defined under Bangladesh law. In the U.S., our federal rules of evidence provide that a writing consists of letters, words, numbers, or their equivalent set down in any form. So in the U.S., it doesn't have to be on a substance. It's something set down in any form. The definition for a recording is similar. It's also something set down in any form. And a photo is defined as a photographic image or its equivalent stored in any form. So it's so much easier to use digital evidence under the U.S. law because our code specifically permits it. Our rules provide, as long as something is relevant, which Professor Supan also talked about, the form in which it exists doesn't matter. If it's relevant and it's been set down in some form, it will be admissible in a U.S. court. Now, as Professor Supan mentioned, the situation in Bangladesh is different. Article 3 of the Evidence Act of 1872 defines document focusing on substance. It has to be recorded. So it's something upon a substance which is very different from the U.S. rules. The substance requirement makes it more difficult for evidence to be administered here. Now, Professor Supan, I've spent a fair amount of time with Professor Supan. He's explained, as he did to you, that you can make a good argument that you can define the terms broadly enough so that substance could be something like digital, to include digital evidence. But the problem is that judges here are going to likely to insist that the substance be defined. And substance, looking at the examples under Rule 3, the examples are all something like on a document, on a piece of paper, on a on something solid. And digital evidence is stored anymore in a cloud. And you cannot explain to a judge how the cloud is a substance. I would not want to be the person trying to make that argument to a judge. Would you, Professor Sapon? No. So, because of the requirement of substance under the Bangladesh Evidence Act, that makes it much more difficult to get around it. Now, talking with prosecutors, judges, officials from the law ministry, professors like Professor Sapon, and others, virtually everyone agrees that digital evidence is something they would like to be able to use. I don't blame them. Without digital evidence, most of our cases would be almost impossible to prove. One of the questions I'm here to try to help Bangladesh answer is, how do you do that? How do you find what's the best way to approach the question so that digital evidence can be admitted here in Bangladesh? And as Professor Sahan pointed out, one thing Bangladesh has done is enact a number of special laws. So we talked about the International Crimes Tribunal Act of 2006, the Information and Communication Technology Act, also 2006, the Pornography Control Act, the Anti-Terrorism Act, among others, provide for some form of digital evidence or digital devices. But is it really effective anytime you want to change the law and make it possible to allow digital evidence to be admitted? Do you want to wait and have Parliament enact a new law? Is that really very practical? What do you think? Do you think that's something you want to do? Anytime there's a change, you want to go to Parliament and say, please, Parliament, spend time drafting this one law so we can address this one particular issue. Granted, it's not going to address all these other 50 or 60 cases, but it will address one case. Do you think that's very practical? No? No. So, I've been trying to work with decision makers here to figure out what you can do. Before I go on, the Information and Communication Technology Act of 2006 provides that it sort of broadly admits digital evidence into those cases. But there's a problem. One of the papers that I read, written by Saikur Rahman, a barrister who's serving as an additional district and sessions judge, says that the ICT Act, while it amended the definition under Section 3 of the Evidence Act to include a document created by electronic method, or machine, he isn't convinced that judges here are going to consider the underlying electronic information even if you print it out. So it's not entirely clear that even when Parliament tries to make a patch, that it's going to work. So, as I said, special laws are one way that Bangladesh has attempted to address the use of digital evidence in specific cases. Going forward, Bangladesh is going to continue to do that, but let's face it, technology changes so quickly that even if you change the law now, we're so far behind the curve that technology has already moved on well past what we just fixed. So the fix is no longer helpful. And talking to people here in Bangladesh, it strikes me that this is not really the way that they think is most effective. I mean, your students, do you think that's the way, do you want to do that? Or would you rather look at a broader fix? I think most of us want to look at a broader fix. So a lot of people I've spoken with here suggest amending the definition of document under Section 3 of the Evidence Act. And one thing to note, India has done that. Zanzibar did that. They both use the Evidence Act of 1872 just as Bangladesh does, but they have changed specific provisions of the acts to allow for the use of digital evidence. As Professor Supan pointed out, in 50 years, basically there have been no changes to the Evidence Act of 1872. And in fact, probably in almost 150 years there have been some minor changes, as he said, definitional changes, changes reflecting Bangladesh's independence, so changing the names of cities where things happened. Really, in terms of substance, there haven't been any real changes. One thing to think about, the Commonwealth, of which Bangladesh is a proud member, has produced a number of model laws. They have a model law on digital evidence, which is something that Bangladesh may consider incorporating into its Evidence Act of 1872. Change is a great thing, but change is also very, very hard. Inertia is a very difficult thing to overcome. The Evidence Act has been around almost 150 years. It's what people are used to. They recognize it has problems, but change is never easy. So to help develop an interest in change, I've been working with Professor Supan and others to build a comfort level among prosecutors and judges and lawyers with digital evidence. I believe Professor Supan mentioned that we've done a number of seminars in Chittagong, Catagram, Sylhet, Pulna, bringing Professor Supan, bringing experts from the U.S., bringing an FBI agent to help make judges and prosecutors more comfortable with digital evidence. It's a new concept. Yes, you use it, but people don't always understand how it works. So we've been doing the presentations. One of the questions, as I've been talking with prosecutors and judges, they've been concerned about authenticity. The judges, one of the first things when we sit down and I ask about digital evidence, they're concerned, how do we know that it hasn't changed from the time it was collected to the time it's offered in trial? And Professor Supan mentioned the hashing technique, and when we demonstrated that to prosecutors and judges, it's like an aha moment. It's like, wow, we can verify that something hasn't changed. And by being able to verify that it hasn't changed, judges are much less concerned that somehow something is going to be degraded or going to be tampered with. So that's one of the biggest concerns, is just how do you make sure something is authentic, and using the hashing technique is one way of doing that. And you are very well placed to understand just how much evidence there is on your phones. There's so much evidence in a digital device that would be so helpful in a trial and would make trials move more quickly. I know that the government here has been working very hard to reduce the backlog of cases. There is a significant backlog of cases, and anything that can be done to help speed up cases without preventing justice from being done is a good thing. And if you're able to introduce digital evidence with all that is contained in the digital devices and the analysis of that evidence, that can speed up trials. It can make it much easier for the judge to determine the relevant facts and apply the law to those facts. So, by being able to work with prosecutors and judges and show them what you can do with this evidence, it's really helped, I think, convince them, not that they really need convincing, but help further point out how helpful it would be to make some changes to the Evidence Act of 1872 to allow the use of digital evidence. Um, Now, I'm going to ask for your help because convincing the government to make a change of this kind requires a lot of work. And you understand digital evidence really, really well. You've had professors like Professor Suhan to help explain all of the great things that digital evidence can provide. But I need you to help me by talking to judges, talking to the prosecutors, talking to the extent you know parliamentarians or people who work for parliament members of parliament. Help them understand how helpful it would be and how much use it would be to make a change in the law to allow digital evidence to be more broadly and widely accepted. That's something that you can do, and please do it, because I know that Bangladesh aspires to deliver fair justice in a time-efficient manner. And right now, because digital evidence is not widely accepted, it makes it harder to do that, and that's not fair to you as lawyers, soon-to-be lawyers. It's not fair to your clients. It's not fair to the people of Bangladesh. So let's all work together to help Bangladesh move forward. And I think by finding ways to make more use of digital evidence, that's a great thing. And please, anything we can do to help, I appreciate it. And I really appreciate the time and opportunity to come and talk to you today. Thank you so much.
Thank you.